Hi everyone, welcome to the live virtual classes of Board of Studies ICAI on CA intermediate course. And as you are aware, we have started with a new topic, that is General Clauses Act 1897. It is a series of 4 lectures which we will talk about. 2 lectures on the General Clauses Act and 2 lectures we will devote to interpretation. So these are 2 components actually in understanding the laws. And these sessions are general sessions, but very important sessions because you as CAs, whenever you will be working or at present for your examination, you have to understand the legislation which you are dealing with. And primarily you will be dealing with some major important legislations like Companies Act, the Chartered Accountants Act, the Company Secretaries Act. Then you will be also discussing with Insolvency and Bankruptcy Code. All these legislations have involved some interpretation element in it. And though you are not lawyer, you will be assisted by lawyers. But at the end of the day, you need to also understand the repercussion of these legislations. So to that effect, this topic is very important for you all to understand it in a proper way as to how the interpretation thing happens and what is the utility of analyzing these terms, because in law, even a comma would make a difference in the interpretation. And that is what the courts in India have been doing. So if you see the High Court, if you see the Supreme Court, their interpretation are based on small terms like may, shall, and, or, comma. So these are also making a lot of difference as far as the interpretation and understanding of the law is concerned. So this General Clauses Act basically is a legislation which will provide you with the interpretation element when there are some confusions in a legislation. So as regards particular issues, and that is what has been mentioned in this act, and we are going to cover that particular act in these 2 sessions. Today, I intend to take you about half of the act almost, and then tomorrow we will talk about the remaining portion. But before I proceed, let us try to understand about the objective of this legislation and what is the purport, why this particular legislation came up, what is the utility of it, and how this legislation is useful for lawyers as well as anybody else who wants to interpret the law. So if we see, this is what is the learning outcomes of this particular chapter. So at the end of the chapter, you are supposed to explain the purpose of General Clauses Act. You should also acquire some basic understanding of the legislation, how legislation is arranged. And this is important because many a times you will be coming across new legislations which you have not read before. And then in that situation, you should be able to understand how the legislation is arranged. So that I will tell you. Then you should know the general definitions under the Act. What are the general definitions provided? And you should be able to identify general rules of construction. This we will supplement it when we cover our interpretation class. There we will talk about this interpretation in more detail, right? So that will be more of a theoretical understanding along with case laws. But here we are talking about a statute itself, which provides for rules of construction. So we will see what rules of construction this particular law is talking about. Then we will see you should be able to explain the powers as to orders, rules, and etc., which can be made under the enactments, and gain general knowledge or knowledge of other miscellaneous provisions under the law. As you could see in this particular picture, it says the General Clauses Act 1897. So see, this is the legislation which is prior to we getting independence, our constitution, but still it governs, like many other legislation, the interpretation of laws, right? It is quite interesting. So you are all aware that we are now revamping our legislations into the modern era. I hope this legislation also comes into the amendment parameter and a new legislation comes in its place in due course. But as of now, the General Clauses Act is 1897 law, which we are, taking recourse to. But interesting point here to note is that it talks about the Incorporating Jammu and Kashmir Reorganization Act 2019. So after the Jammu and Kashmir Reorganization Act, those provisions have been made applicable to the whole of India. But you should be aware that General Clauses Act does not talk about the extent and commencement. Still, this law has now been made applicable through this legislation to the state of Jammu and Kashmir as well. At the bottom, you are able to see with state amendments, right? So this legislation is applicable to central acts, but there are state General Clauses Act also. Like, for example, the Karnataka General Clauses Act 1899 is a state General Clauses Act which applies to state legislations. So you will find different General Clauses Act in different states, and there are amendments with that particular state input or state legislation. So we will talk about these things as well in due course. Moving further, this is what is the arrangement of the General Clauses Act, and you can see and have a look at the General Clauses Act overall perspective. And here, as you see, the first point is about the section 1 is preliminary, then general definitions, which is in the section 324A, general rules of construction 5 to 30. And I intend to cover till this particular point in today's session. And then in the next session, we will talk about powers and functionary, that is section 14 to 19, provisions as to orders, rules, etc. made under enactments, that is 20 to 24. And there are miscellaneous provisions from 25 to 30. So as you can see, this is a legislation which carries about 30 sections, and it has got a schedule also, but that is now repealed. So a number of sections in this law has been repealed, which were pre-independence era provisions. So those were repealed. And now we will see each provisions one by one. If you see the content of this law, it spans like this. So as I told you before, the section 1 talks about short title, and section 2 is repealed. That is again pre-independence law. And then general definitions are provided. Definition is there, and how these definitions will be applicable to the laws which are enacted prior constitution. So if you read this General Clauses Act, you will distinctly see the period of applicability. So there are period which is prior to constitution, there is period which is after constitution, right? And there is also two intervening periods which have been mentioned here. Is the General Clauses Act got amended many times, and those periods are also provided. So we will talk about that in a brief while. I'll tell you. Then as you see, there are general rules of construction, section 5, 5A, which is repealed, 6, 6A, 7, 8, like that, till 13. And then power and functionaries. So it talks about the different powers which can be exercised by the authorities, ex officio, and how do you interpret them? Objectively, the law is for interpretation. And provisions as to orders, rules, etc., and then miscellaneous provisions. So this is what this is the frame of the act and frame of the legislation, as you are able to see from here. Now, if you see here, I have got one input from a Apurus. Repealed means removed. No, removal is something different. Repealed is something different, because it has got a legal connotation. When you say an act is repealed, that means that this is no more existence. And but if you see, there is something which is known as a doctrine of eclipse, which is not there part of your syllabus, but probably we will see that in interpretation. When I teach you interpretation, I will cover that in detail. But briefly to tell you that even a repealed act, if tomorrow has to be revived, it can be revived, okay, by way of statutory provision. And then that is why it is said that repealed law does not get removed permanently, okay, it is eclipsed. by the subsequent legislation. And if that eclipse goes away, then again, the law can be revived. So that is a concept in law, and it is a detailed concept. We will, restrain from going into that particular thing right now. Let me explain you this General Clauses Act in a proper way. You understand this concept properly, and then we will talk about interpretation with cases and case laws in subsequent sessions. Now, coming to the objects and reasons of General Clauses Act, there are different reports on this aspect, and one of the important reports, though this is not part of your syllabus, but if you are interested more in reading about General Clauses Act and how this has come about, what is its relevance, I would suggest you to go through the Law Commission of India 183rd report, which is a continuum on General Clauses Act. There, they have traced the history. They have talked about many things. It is a big report. And if you are interested more in reading in this, some of you may be curious, you can do that. Otherwise, it is not a necessity as far as your course is concerned. For your course, you need to understand that what are the objects and reasons of General Clauses Act. So as you would see, this is the General Clauses Act. And if you see on the beginning of this legislation, it is talking about statements of objects and reasons. And in the statement of objects and reasons, it is 1897 law. And if you have a look at this, it is talking about why this particular law actually came into picture, right? And it clearly says the first enactment of this kind was Lord Broughman's Act. Okay. The provision of the statute were adapted in India and somewhat amplified by the General Clauses Act of 1868 and was further extension of the same principle. So see, it is basically the English Act, the Act of UK, which was brought here. And as you are aware that the legislation mechanism in India is propounded by the Britishers, as you know, and many of our legislation has got the roots in the British laws. And similarly, the General Clauses Act is also having a root in the British legislation. Now, if you see the objective in one of the cases, the Supreme Court has laid down the objective of this legislation, that why this particular legislation is actually in place. And if you have a look at the interpretation which Supreme Court put forth for, Supreme Court in this decision in para 24 says, interpretation statutes such as the General Clauses Act are enactments intended to set standards in construction of statutes. When I say construction of statutes, it is not making of the statutes. Okay. Here, construction means interpretation. Okay. How do you interpret the statutes? Or you can read it like this, that interpretation statutes such as General Clauses Act are enactments intended to set standards in interpretation of the statutes. So, courts cannot lay down a law. Courts cannot enact a legislation, right? They will lay down the law. They will interpret it. They will, tell you the context or the reasoning, or they will tell you that how this law has to be applied, or they will interpret that particular law for application. The expression construction is of seminal importance, and that is what the court goes ahead and explains, as it is oriented towards enabling a seeker of the text of a statute to understand the true meaning of the words and their intendment. Apart from setting coherent and consistent methods of understanding enactments, the interpretation statutes also subserve the purpose of reducing prolixity of legislations. So see, what is one of the beauty of this particular General Clauses Act is that it provides interpretation of many terms or many dimensions. And you don't have to repeat those particular things in all legislation. Say, for example, in Central Act, if there is one point which is explained in General Clauses Act, it is not necessary to explain those particular things, these 30 provisions in all the legislations. This will be read from General Clauses Act, that yes, this is the general thing which is there. And if you have any confusion, you go back to General Clauses Act and understand that. But if that would not have been there, in every law, you have to provide this much of detailed explanation, right? So this is one element or one benefit of having the General Clauses Act, that you don't have to repeat things. The legislation, number of legislation decreases because of the General Clauses Act. The standard principles formulated in the interpretation of statutes must therefore be read into any and every enactment falling for consideration. And in the ultimate analysis, interpretation statutes or definitions in interpretation clauses are only internal aids of construction of a statutes, right? So if you will see, when we will learn interpretation, there are different aids to construction. So whenever you have to interpret laws, you have to utilize different tools for interpretation, right? So in a legislation, there are various parts, like for example, there is preamble, there is definition, there are different types of interpretation. So there are internal aids to construction and there are external aids to construction. I'll give you one example so that it clarifies right now in your mind, though we are going to have a detailed analysis later. When we say internal aid to construction, that means anything which is internal to the statute, that is becoming internal aid to construction. Like for example, preamble. Preamble of a legislation is there very much in the legislation. And that is one of the ways of interpreting the statute, that is internal aids to construction. Now, parliamentary debate, that is an external aid to construction, because it is not part of the legislation, but it is a supplementary document, or it is an additional document which you can refer to for interpreting the intent of the legislature, right? So when you can use that parliamentary debate, what should be the extent to which you can use that parliamentary debate is dependent upon the interpretation of the court. In different decisions, court have laid down different provisions. Point is that whom they are aiding, these internal aids to construction, is helping whom? So naturally, interpretation is the exclusive domain of the court, and it helps the court to interpret the law in a proper way. Who can interpret law? You, me, interpreting a particular law has no consequence, right? Like say, for example, a chartered accountant interprets a law in a particular way and guides a client. Now, is it final? No, right? So even a decision by a high court is not final. It goes till Supreme Court and then it becomes finalized, right? So whose domain? Who does this help? This helps the courts basically to properly interpret the law and lay down the principles, lay down the law. This is what happens in case of construction statute, and in General Clauses Act is a kind of a construction statute. This is what was held in Pernod Ricard's case versus State of Madhya Pradesh. And this is the latest case in which the court has provided the objects and reasons and the objective of General Clauses Act. I hope this sets a bit of a context in your mind that why these General Clauses Act are there. If you have a look at the actual objects, purpose, and importance of the General Clauses Act, it is basically to shorten the language of central acts. As I mentioned you before, these 30 provisions does not need to be repeated again and again in central acts. A person can just refer to the General Clauses Act. Second, to provide as far as possible for uniformity of expression in central acts by giving definition of a series of terms in common use. Like say, for example, calendar year, day. These are all defined in General Clauses Act, and you don't have to again and again define. And if you say define these in different legislation, there may be a problem in future for interpretation because they may not be same, right? One example I can give you is about the definition of control. So the definition of control in SEBI Act and Companies Act is different. And that creates a lot of complications, because in one of the context it is affirmative, in one of the context it is in a negative sense. So interpretation wise it becomes problematic, right? So if the definition would have been same, it would have been not be a problem. Similarly, if you see the definition of person, it is defined in number of ways in different legislation. So though in General Clauses Act we don't find that particular definition in a broader sense. So let us look at the other provision. What is the other object? Other object is to state explicitly certain convenient rules for the construction and interpretation of central acts. And finally, to guard against slips and oversights by importing into every act certain common form clauses, which otherwise ought to be inserted in every central act. Now, in this case, the Chief Inspector of Mines versus Lala Karamchand, the court went ahead and further explained the General Clauses Act and its importance and purpose. And it said the purpose of this act is to place in one single statute different provisions as regards interpretation of words and legal principles, which would otherwise have to be specified separately in many different acts and regulations. The purpose of the act is to avoid superfluity of language in statutes wherever it is possible to do so. So whatever General Clauses Act says, whether as regards to the meaning of the words or regards legal principles, has to be read in every statute to which it applies. So this is what is the purpose of the General Clauses Act. I hope the purpose of the General Clauses Act is clear to you people, right? Now, if you talk about, the interpretation part of it, I've already explained you the aids to construction, internal aids or external aids to construction. Aid basically means assistance or help. So whenever court is posed with a provision for interpretation, they need to go back and see that what that legislation means. And for that, you move to many things. Like say, for example, definition clause. Definition clause of a legislation itself is an internal aid to constitution. Internal aid to construction, right? So if you have to interpret a particular provision, you go back again to definition clause, see what definition says, okay? So this is an important part. Like say, for example, in IBC, we talk about financial creditor. Financial creditor has been defined in IBC, right? So wherever financial creditor as a word has been referred, you go back again and again to the definition clause to find out what financial creditor basically means. If there is a definition of default, then what is the definition? What is the meaning of that particular term? Default is mentioned there clearly, right? So whenever you will come across the term default, you will go back to definition and see what exactly it is saying. This is called internal aid to constitution. But while having a discussion on default or maybe resolution plan, whether to allow the promoter or the former promoter of that particular company, which is under resolution, to submit for the resolution plan or not is a very important question to be answered. And the court for this has again referred to the parliamentary debate also, that what legislature actually wanted, whether they wanted that the existing person who has committed the default should be permitted to give the resolution plan also. That is how there was a germination of a new section in the IBC, that is 29A, right? So these are basically the purpose, or you can say the aids to construction. Now, let us move further and talk about another example, right? And this example is basically about interpretation and construction of statutes and how you deal with that particular part. Now, if I have to see this example, it basically says appointment of advocate to take possession of secured assets, right? And this is with reference to SARFAESI Act. SARFAESI Act, people must be aware. If you are not aware, I'll just tell you. SARFAESI law deals with the recovery of proceeds, right? So it gives power to the banks to confiscate the secured asset and then auction it. For this, they don't have to go to court for an order. Under Section 13, they can just, seize the secured assets and then proceed against that particular asset. So here, to do that particular activity, the law mentions the term magistrate, CJM basically. And here the question was whether it is open to the district magistrate or chief metropolitan magistrate to appoint an advocate and authorize him to take possession of the secured assets. So here the law says CJM, but whether the CJM is authorized to appoint a lawyer or any advocate to be the commissioner or taking the possession of it? That was the question basically in this particular case. Here, the court went ahead and it interpreted the term, and in fact, it dealt with number of dimensions. Like it talked that there are different types of subordination, like administrative subordination, statutory subordination, functional subordination, and it gave a logical understanding to this particular provision. And it said, it is common knowledge that in the respective jurisdiction, there is only one CMM or DM, right? If he is expected to reach at every location himself for taking possession, in some jurisdictions, it would be impracticable. It is not possible for the CJM, CMM or DM to move everywhere. If not possible for him to do so, owing to larger number of applications in the given jurisdiction, being a commercial city, accordingly, strict construct would defeat the legislative intent and purpose for enacting the 2002 Act, that is SARFAESI Act. Indeed, logistical problems of the Office of CMMDM cannot be the basis to overlook the statutory provision. However, we are persuaded to take the view that an advocate is and must be regarded as an officer of the court and subordinate to CMMDM for the purposes of so-and-so section. So you see, what is that? It is a purposive interpretation. Here it is facilitative interpretation which court has given to the term CMM and DM. So advocate, that particular delegation is permitted here in this case. Court has interpreted that particular term and has provided that, okay, fine, this CMM and DM would also include a representative of CMM and DM who is an advocate. So this is how the interpretation happens. I hope this clarifies in your mind about this. Okay. Now, let us talk about another important provision under the Constitution, basically, because this is the important provision under Constitution, that is Article 13. Article 13 provides for different clauses, okay? And 13.1 basically talks that all laws in force in territory of India before the commencement of this Constitution, if they are inconsistent with the Part 3, that is basically fundamental rights, shall, to the extent of such inconsistency, be provided. So basically, Article 13 of the Constitution clearly says that any law which violates the fundamental right will be void. You cannot enact a law, but this 13.1 is talking about pre-constitutional laws. So any pre-constitutional law passed before, this includes even General Clauses Act. If it violates the fundamental rights, it won't be, it would be void. Then 13.2 talks about the state shall not make any law. So this is futuristic law. So it is saying that after the Constitution, the state is not permitted. State includes your, if you see Article 12 of the Constitution, it defines the state, and there's a very elaborate decision. It includes union, it includes the state governments, it includes the local authorities. So they cannot enact a law which abridges or takes away the right conferred in this part, that is fundamental rights, to the citizens. Okay, if that does, then it will be it will not be accepted, and that is where it is called the challenge to the constitutionality of the legislation. So when we say that the Constitutional Court is seized with the matter and there is a challenge to the constitutionality of the law, basically we are meaning this, that the law has provisions which violates the fundamental rights of the Constitution or alleged violation of the fundamental rights of the citizen, and that is why that is being challenged before the court to be struck down. Now, Article 13.3 is important, which talks about definition of law, and it defines law. And how does it define? It says in this article, unless the context otherwise requires, the term law includes all these, that is ordinances, orders, bylaws, rules, regulations, notifications, customs or usage having the force of law in the territory of India. So General Clauses Act, when we are talking about, it applies to all kind of laws, but basically central law, right? So it applies to ordinances, it applies to orders. Here my point, this definition of law is that law does not mean only the act, right? The legislation which has been passed by the Parliament of India, but it also includes rules made by the government, regulations made by authorities, notifications issued by the government. There may be customs or usage. There may be ordinances which are passed by the government. There may be judicial orders which have been given. All these things are included into law. Now, there is also a term called laws in force. So laws in force basically includes laws passed or made by the legislature or competent authority in the territory of India before the commencement of the constitution and not previously repealed. So if a law which has been passed before the coming up of the constitution and which has not yet been repealed, that will be considered as laws in force. And see, that is why the present government, you may be aware that it has repealed so many laws, right? What is the objective? That obsolete laws should not be there on the paper, because if they are there, they are in force. And there is a famous maxim which says ignorance of law is no excuse. So if you have a law in place and that has lived its utility, there is no need for that particular law, and you are still having that particular law, then it is of no use, basically, right? So laws in force talks about all the legislations which have been passed, which were in existence before the constitution came into picture, and they have not been repealed. Let us take another example. As you can see in this particular picture, that there is a fish a person is carrying. So whether right to transfer fishing right is an immovable property or a movable property? Yes. What do you think? Is it a movable property or an immovable property? You can use your chat box for answering that. Movable property. Immovable. Okay. Movable. Interesting. Movable. Okay. Many of you are saying movable. Okay. 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 It is right of fishing. Okay. This is not the fish. We are not talking about the fish. We are talking about the right of fishing in a pond. Say, for example, there is a big pond and you want to transfer the right of fishing in the pond to someone. What it will be? It will be movable or immovable. Okay, interesting. This was a issue. This was a question. So Pranav says it is not a property. Okay, fine. It is quite an interesting one. Thank you for giving your inputs. If you see and if you read your course material, probably many of you who has answered immovable property has read the course material. People who have not answered movable property have not yet read it. So please read it. And if you will see it, this is the case, Anand Behera versus State of Orissa. And this question was there in this case. Okay. And if you see Section 3 of the Transfer of Property Act, whether movable property or immovable property, whatever you want to make a transfer, then Transfer of Property Act comes into picture. So Section 3 of the Transfer of Property Act does not define the term of, except to say that immovable property does not include standing timber, growing crops, or grass. A fish will not come under this category. It is talking about standing timber. It is talking about growing crops. It is talking about grass. Now, this is the situation. Now, here, how do you interpret it? Because fish is not included here. So you go to the General Clauses Act and you see Section 326 of the General Clauses Act, which reads as under. It says, immovable property shall include land, benefits to arise out of the land, and things attached to the earth or permanently fastened to anything attached to the earth. So here, benefits to arise out of the land has been taken into consideration, and fish is considered as a profit a pendre. That means a legal right allowing a person to extract something of value from another's land. And this is regarded as a benefit arising out of a land. It follows that it is a immovable property within the meaning of the Transfer of Property Act. So now see, if there is a oil inside that particular land, whether it will be movable or immovable as per this interpretation, definitely it will become an immovable property, right? So this is how you have to talk about. So any benefit which is arising out of the land will be considered as immovable property. This is the benefit. This is the interpretation applying General Clauses Act. I hope you have understood the context. So whenever there is clarity needed in any of the interpretation in any other legislation, and you are not finding that clarity, at least once you should go back to General Clauses Act to find that clarity. I hope this this helps you in understanding this part. Okay. Now, when we are talking about this, let us move further. And in this, the court basically held that right to catch or carry fish is an immovable property. Now we are coming to the legislation now, the General Clauses Act. And General Clauses Act begins with this, that is the title. This is called short title, and it is referred to as General Clauses Act 1897. You should see that any law begins with section 1, and it is a short title, application and commencement of the legislation. I have given you a comparative here. So if you see the General Clauses Act, it just mentions one line. That is, this act may be called General Clauses Act. It is not saying anything further. But if you see section 1 of this Bharatiya Sakshya Adhiniyam, that is the new Evidence Act, it has got 3 subclauses, as you can see. It is mentioning the name. Second, it is talking about its application, to which things it will be applicable. And third, it talks about when it will come into force. Okay. So these are the 3 different terms. We will talk about it in a while. I just wanted to give you a comparison between 2 legislation. Now, if you will see, General Clauses Act also applies to the Constitution. So if you have to interpret Constitution, there also you can utilize General Clauses Act. And Article 367 of the Constitution of India itself authorizes the General Clauses Act for the interpretation of Constitution. As you can read, Article 367 of the Constitution says, unless the context otherwise requires, the General Clauses Act 1897 shall, subject to any adaptation and modifications that may be made therein under Article 372, apply for the interpretation of this Constitution as it applies for the interpretation of an act of the legislature of the Dominion of India. This is what is the provision under the Constitution, which makes the General Clauses Act applicable for interpretation of the Constitution of India also. While interpreting the laws, one thing one has to keep in mind always is that context is the king. Context is always the king. So you cannot just interpret General Clauses Act. Say, for example, there is a conflict between a statute and General Clauses Act. Which will prevail? What do you think? If there is a conflict in a term between General Clauses Act and a specific legislation, which one will prevail in interpretation? The statute. Yes, the statute will prevail. Why statute will prevail? Because that is a specific thing which is mentioned. The legislation is enacted for a particular purpose. General Clauses Act only comes into picture when there is no guidance provided in the specific statute. Then you move to the General Clauses Act to find out the interpretation. If the statute or legislation is very clear in its part, then there is no need for you to go back to General Clauses Act. So utility of General Clauses Act only comes when there is no clarity provided by the legislation. Okay. Now, if you will see, the General Clauses Act applies to Act of the Indian Parliament. It applies to the Act of the Dominion Legislature. This Dominion Legislature is the period of our country when we got independence and the Constitution was yet to be enacted. This period is referred to as Acts of the Dominion Legislature. And the Act passed before the commencement of the constitution by the governor. So there are pre-constitutional laws. The third point is pre-constitutional laws. The second point is the laws between the passage of the constitution and our independence. And third is acts of Indian Parliament, definitely after constitution. So the post-constitution, all legislation by the Indian Parliament, the General Clauses Act applies to that. I hope this is clear. This particular section 1 is clear to you people. Now let us move further and talk about the structure of a legislation, and let us understand some basic of this legislation. So I have taken as an example, this is the legislation. Okay, this is a legislation, a latest legislation which has been passed is Digital Personal Data Protection Act. You must be referring to this in news. A lot of now rules they have given for public consultation. And if you will see here, what are the important things which you are noticing here? You are noticing the Gazette of India is written. So there is a gazette in which these legislations are published. Once it is published, then it is available to everybody's access. There you are seeing date of publication of the act in the Gazette. So the publication of date on the Gazette and the date on which the President provides assent to this legislation may be different. These two things can be different. It is not necessary that it will happen in the same day. Generally, you will find same date, but many a times you may not find the same date. And then you are able to see the title of the law. This is the complete title of the law, the Digital Personal Data Protection Act 2023. In bracket, you are seeing number 22 of 2023. That means this is the 22nd legislation in the year 2023, right? So this is how they name the act or name the law. So this is the law which you are able to see. If you see the General Clauses Act, it is Act 10 of 1897. So it was the 10th legislation in that particular year. I hope these terms are clear to you. Now, let me take you further. And if you will see here, there is something which is called the General Rules of Construction, but I am referring to section 5 here directly because I wanted to make a point, and we will cover section 5 also here. So if you will see, it is saying coming into operation of the enactments. So when we talk about coming into operation of the enactments, let's just a second. Yeah. So let me first, I have to talk about this. So here you can see in the Digital Personal Data Protection Law, you are able to see the first thing on the top. What is that? An act to provide for processing of, if you read the preamble, it is talking about the context, why this particular law is in existence. Okay. So you are able to see here very clearly why this particular law is in existence. To provide the processing of data, recognizing the rights, and it is also talking about the processing of personal data, lawful purposes. So this is what is the preamble of the legislation. This is again an aid to Constitution. Many a times while interpreting the provisions below, they will go back to preamble and see that what preamble says. Like say, for example, our preamble of the Constitution. It is, Dr. Ambedkar said that this is the torch with which you should look at the Constitution. Preamble talks about everything. Its philosophy, its ethos. And in Constitution Day, we actually read preamble. We again and again read preamble. Why? Because that gives you the vision of the Constitution. Then it says, be enacted by Parliament in the 74th year of the Republic of India as follows. So this is what the law begins. Any law which you will read, it begins like this. Okay. First is your date and title of the law, main title of the law, presidential assent, the date on which it was given, then preamble, and then chapters begin. And this is the chapter 1 or first section generally is preliminary. Chapter 1 is preliminary. And preliminary chapters talk about two major things. One, short title and commencement. And the second one is definitions. So here, if you will see, here the short title and commencement is talked about. The first is short title. This act may be called Digital Personal Data Protection Act. Second, it shall come into force on such date as the central government may by notification in the official gazette appoint, and different dates may be appointed from different provisions of this act, and any reference in any such provision to the commencement of this act shall be constituted as a reference to the coming into force of that provision. So this is the commencement and extent of application, which you will find in General Clauses Act. It is not there, right? Now, after that, there is a definition clause which defines everything. And as I told you, these are all internal aid to construction. That means these are all the interpretation provisions. So if you will see, to interpret any provisions in the act of the DPDP Act, you come back to the definition clause. Like say, for example, there is a chairperson or there is a board which is mentioned. This board here in this legislation means Data Protection Board of India. It does not mean cricket board or it does not mean insolvency board. It means the Data Protection Board of India. So whenever you are reading the Digital Personal Data Protection Act, wherever there is a term board used in this law would mean the Data Protection Board, right? Making sense? So this is how the legislation is arranged. After this, all the legislation will have different chapters. And in the chapter, there will be sections. They will be logically arranged. And you will also find in many legislation a schedule. So there will be a schedule towards the end, which contains, say, for example, many a times it will contain fees, structure, it will contain maybe hierarchy of documents like that. So these are all schedules. Here in this context of commencement, Section 5 of the General Clauses Act is important. So I will take you now to Section 5 of the General Clauses Act. So what Section 5 of the General Clauses Act says? It says when any central act is not expressed to come into operation on a particular day, then it shall come into operation on the day on which it receives the assent of whom? Of the President, the Act Parliament by the President, or in case of central act made before the commencement of the Constitution by the Governor General. Now this Governor General thing is off almost because now we are 75 years old Constitution. So generally these interpretation of Governor General does not come into picture. I don't find in the latest cases these things are coming. But the second B point is important. What is the importance of this particular point? The importance of this point is that the act, it is not necessary that every provision, all provision will be notified on the same day. Here it is clearly saying, unless the contrary is expressed, a central act or regulation shall be constituted as coming into operation immediately on the expiration of the day preceding its commencement. So what it is saying, if say for example, commencement day is 15th January 2025, the law will come into operation immediately after expiration of when this will come. Can you put in your chat box when this particular law will come into picture? If there is a law which commences or the President has given an assent on 15th, when the law will commence as per this interpretation of 5 subclause 3? 16th. Okay, can you be exact? 16th means what? Morning, 8 a.m., 4 a.m. So when we are talking about 16th, 12 a.m. Very good. So this is what will be the time. Okay. The next day immediately. Immediately, that means after 12. So the law will come into force. This you must have seen. A lot of fanfare happened when this BNS, BNSS, all these legislation, new criminal laws were enacted. Then they publicize it. Okay, from night 12 o'clock, the new laws will be coming into force. Very good. Now, this is what it is talking about. it also sets into context one important thing, that is presumption against retrospectivity. We will talk about it in a while. Let us talk of few examples more. Like the Companies Act received the assent of the President of India on 29th August and was notified in the official gazette on 30th August with the enforcement of Section 1 of the Act. Accordingly, the Companies Act came into enforcement on the date of its publication in the official gazette. So, irrespective of the fact that it was given assent, I gave you this example before also. Then see this legislation. SEBI issue of capital and disclosure requirements, Fifth Amendment Regulation 2015. It was issued by SEBI wide notification dated 14th August 2015. And it was made prospectively applicable from 1st of January 2016 rather than the date of notification in the official gazette. So the government can always provide, and that is why this term, unless the contrary is expressed, right? What does it mean? A contrary can be expressed. Government can issue a notification saying that the law will be implemented in parts. And whenever there will be a notification of that provision, then that will be notified. However, courts have put a caution in one of the cases, like say, for example, this A.K. Roy versus Union of India. The Supreme Court said that the law empowers you to bring any of the provisions into operation on any day which you deem fit. No court can issue a mandamus with a view to compel the government to bring the same into operation on a particular day. No mandamus can be issued. However, in another case, the court held that you should be, it should not be a situation that you have having a law in the place and it is not getting notified for years and years. That should not be the case. That is what in one of the cases Supreme Court has said. I am not remembering right now the case, but I think it is there in your course. Otherwise, I have read it somewhere where it is the court has said that you cannot hold this for time immemorial. The concept of presumption against retrospectivity basically means that any law which comes into operation generally will apply prospectively. That means in future. It cannot be backdated. So you cannot have a legislation today to apply for 5 years back, right? It is not advisable. However, it is not completely outruled. So there may be situations where a retrospective application of law can be there. Okay. But generally, there cannot be a law which is applied retrospectively. It is presumed that the law is prospectively applied. The day on which the law passes, after that only it applies. It does not apply to the situations prior to that particular date. This is called presumption against retrospectivity. Now, this I have told you. If now there is another important thing which I wanted to discuss with you is delegated legislation. So I have already given you the definition of law under Article 13 of the Constitution, right? Now, if you will see, any law provides for powers to authorities to make rules and regulations. So, by the way, I am just getting curious here that what is the difference between rules and regulations? Do you have any idea? Rules and regulations. Any idea? What is the difference? Any one of you? What is a... Yes, there are retrospective laws. I have already told that there may be retrospective laws. It is not necessary that retrospective laws cannot be there. Yes. Go ahead. Any input which you have here? I'm just having a look at the question in the chat, in the portal. Okay, fine. There are no questions. There's only one input. Okay, yes. Regulation is bigger than the rule. Okay, Ambeshwari, it is other way around. Rule is always bigger than regulations. Yes, rule are made by the government which need to be followed blindly. Interesting. Rules are specific guidelines and instruction created by organization. Okay. Okay, let me explain you. So if you will see, there are rule making powers and regulation making powers, which is there in case of delegated legislation. So let us take an example of this, Digital Data Protection Act. So you can see here, there are power to make rules under 40, it is given. It says the central government may, by notification and subject to the condition of previous publication, make rules not inconsistent with the provisions of the Act to carry out the purposes of the Act. So see, this is a delegated legislation. So Act delegates. Who passes the Act? It is the Parliament. So Parliament passes the law. Then who makes the rule? Central government makes the rule. As per the allocation of business rules, central government has different ministries who has got power to make rules in this. In this case of the digital data protection, basically it is the Ministry of Information Technology which has got the power to make the, okay, it suggests the rules and make the rules, and then it is laid in the Parliament again. Then who will make the regulations? Regulations will be made by the authorities, right? Like in your case, for example, for the chartered accountants, now there is a new authority, right? National Financial Reporting Authority, NFRA. So NFRA has got power to make regulations. So they can make regulations. They cannot make rules. They can make regulations. Who can make rules? In that case, it is the Ministry of Corporate Affairs which can make rules. Parliament can make law. That is, I hope this clarifies the difference between Act, rules, and regulations. Now, if we see, this is what I said, Ministry of Corporate Affairs in your case is the rule-making authority. If you see this Insolvency Bankruptcy Board of India code, it says in exercise of powers conferred on so and so, the regulations are made. So IBBI makes the regulation in case of the Insolvency and Bankruptcy Code. I have already talked about the example of National Financial Reporting Authority. Now let us move further and talk about few terminologies on means and include and this dimension. So if you will see means or include, this term you will find at many places. Generally, you will find it in definition clause. So it will say that this means so and so. This includes so and so, right? So it has got a meaning. It has got an interpretation. It has got an understanding in law. So whenever legislature defines a word, artificially it may define a word. Like for example, in IPC, it has defined the term he. It says whatever he means she, her, whatever terms, connotation. So he means she. Legislature can define that. So if you will see the definition clause, and you will find in the definition, there is a term mean, and it says that this is to mean such and such. The definition is basically restrictive in nature because you cannot include anything further. But when there is a definition which is declared to include such and such, the definition is extensive in nature. So you can include of similar purport, you can include similar kind of things. So when by an amending act, the word includes was substituted by the word means, then in that situation, you have to read the intent of the legislature that you are trying to restrict the nature of the definition. In many situations, you will have means and includes together. Okay. So in that situation, if there is means and includes, then that is an exhaustive definition. So you can see here the meaning of expression means, includes, means and include have been. Again, if you want to read more on this, there is a case, Delhi Development Authority versus Bholanath Sharma of 2011. It explains that again in detail. Let us look at some examples, which is there in your course material. So if you will see example 9, definition of company as given in section 220 of the Companies Act. It states company means a company incorporated under this act or any other under any previous company law. So you cannot include LLP in this, right? You cannot include anything other than what is mentioned here because there is a term means. Section 234 says Companies Act defines the term director. A director means a director appointed by the board of a company, nothing else. Unless a person is appointed as a director, then he will not be considered as director. Definition of previously was even if he is acting in that capacity will be considered as a director, but that is not the situation right now. So example 11, word debenture defined under section 230 of the Companies Act states debenture includes, and here you can see it talks about many terms, debenture stock, bonds, or any other instrument of company evidencing a debt, whether constituting a charge on the asset of the company or not. This is basically an inclusive nature definition. That means you can include a few more similar kind of a term, which is also the definition is mentioning. Body corporate or corporation includes a company incorporated outside India. What does it mean? It tells you that yes, this is also the inclusion. This is also the thing. It is an inclusive nature definition. I hope this gives you a clarity as to understanding of means or includes. Now, if we move further and talk about another important terminology and some definitions, but before we move to this particular definition, we see, just a second, give me a second. Yes. So if you will see, there are different definitions which are given in this is another example which I would like to put forward to you. So see subclause 212, and this is coming, I think, from Stamp Act. So in the Stamp Act, there is a definition executed and execution used with reference to instruments mean signed and signature. Instruments include every document by which any right or liability it purports to be created, transferred, limited, extended, extinguished, or recorded. Now here includes, whenever there will be a term include in there, generally there will be one or two more terms attached to it. Lease means a lease of immovable property and includes also a patta so and so. So here you can see means and includes, both are there. That means it is an exhaustive definition. It is an exhaustive definition. This is what was held in the case of Nasruddin versus State of Uttar Pradesh Secretary. So in another case, the Supreme Court said that whenever the expression means is followed by the expression and includes, whether with or without additional words separating means from includes, these expressions indicate that the definition provision is exhaustive as a matter of statutory interpretation. It has also been held that the expression and includes is an expression which extends the definition contained in the words which follows the expression means. This is what has been held in the case of Bharat Cooperative Bank Limited versus Cooperative Bank Employees Union. So there is another important term, shall and may. Many a times you will have this confusion of shall and may. So you see, English is a very interesting language. Okay, you can utilize many terms, and this shall and may are called modal verbs. What does that modal verbs means? Modal verbs are there to assist the verbs. They right? They are modal verbs: can, could, may, might. In legal language, we use shall many a times. Okay. And there is an article written by Mr. Jyoti Sagar. He is the founding partner of J Sagar Associates. Interesting article. I have given a link in the presentation towards the end, and you can refer to that article. It is an interesting article on shall and may. So the word shall is used to raise a presumption of something which is mandatory. So generally, wherever there is a term shall used, it is basically raising a presumption that it is mandatory. The word may, on the other hand, is used to connote something which is not mandatory, but is only directory or enabling. However, you will find that sometimes the word may and shall can be interpreted interchangeably. As I told you, law is a difficult subject because there the courts have interpreted may to mean shall and shall to may, mean may. But not in due course, not in a normal course. Okay. In a normal course, shall means is having a presumption of mandatory. May is having a presumption of directory or enabling. Whereas in certain situation, may mean shall and shall may mean may. It depends. So you have to see the cases. Let us take some example. And let us see what court has said in this. The court said, to elucidate the word may and shall and interpret them, the Supreme Court in Dinesh Chagla Pandey versus High Court of Madhya Pradesh has held as under. The court said like this. The courts have taken a view that where the expression shall has been used, it would not necessarily mean that it is mandatory. It is always dependent upon the facts of a given case. You recollect one of the slide in which I told you context is the king. So here, interpretation, context is always the king. So you have to see the context in which it has been used. Okay. And it says it always depends upon the facts of a given case, the conjunctive reading of the relevant provisions along with other provisions of the rules and purpose sought to be achieved and object behind implementation of such a provision. So this is basically in interpretation referred to as construction, or you can say, purposive construction. So you find the purpose behind the legislation, the objective, the intent, and then ultimately see whether it was shall or may, right? Now, let us take some examples. So this is one example. Section 3 of the Companies Act states that a company may be formed for any lawful purposes. Now, can a company be formed for unlawful purposes? No. So here may has to be read as shall. You cannot say that company, it is saying company may be formed for lawful purposes, hence I can form a company for unlawful purposes also. That cannot be done, right? Here word used may, shall be read as shall. Usage of may here makes it mandatory. Okay, this is an example. Another example is Section 21 of the Companies Act, which provides that documents, proceedings requiring authentication of contract made by or on behalf of the company may be signed by any key managerial personnel or an officer of the company duly authorized by the board in this behalf. Now here usage of may shall be read as may. Here you have to read may as may. Okay. So you don't have, it is not mandatory. It is may. So any authorized person can sign. Generally, wherever the word may will be there you will find a lot of terms around it. Okay. Now, this is another case, that is Vidarbha Industries Power Limited versus Axis Bank Limited. And in this case, the court said, ordinarily the word may is directory. The expression may admit confers discretion to admit. In contrast, the use of the word shall postulates a mandatory requirement. The use of the word shall raises a presumption that a provision is imperative. This is a very important paragraph, by the way, for interpretation of insolvency bankruptcy code. So you will see in insolvency bankruptcy code, there are two kinds of creditors. One is a financial creditor and the other one is a operational creditor. Now here, if you will see here, the section 7 talks about financial creditor, where the term used is shall. And in case of, in 7, it is used may. And whereas in case of section 9, that is operational creditor, it is using the word shall. And the court said that If the legislature has intended to use may in case of section 7, which applies to financial creditor, there a discretion is given to NCLT. Whereas in case of section 9, which relates to the operational creditor, there is no discretion given to the NCLT. This is what is the interpretation which the court has given, Supreme Court has given in this case. So you can see the repercussion of the meaning and definition of a small term like shall and may, right? So this is part of your syllabus. I think it is there. So this is another case which I wanted to touch upon. So now I think we will begin with this preliminary, but I will give you a break of 10-15 minutes, and then we can again resume. Is it fine with you all? So right now, let me tell you, it is 7:10. We meet at 7:25. Okay. In the meanwhile, you are advised to go through the course material, and then you can move ahead. If you have any questions, you can utilize the chat box. You can speak to me, after the 15 minutes break, or you can put the questions in the chat box while you are reading your literature. When we resume, I will start with questions and then we move ahead with the provisions. Yes, yes. There is a article which I told you people that in Bar and Bench it is published by J. Sagar, managing partner of J. Sagar Associates. So read this article. It is quite interesting in why shall should not be overburdened. This is what is their submission. So it is quite interesting article. Now we will open the floor for questions, and you can ask a question, any question or anything till now which you have in your mind. I will be happy to answer any questions or any clarifications you have. Though I think I have addressed most of your questions in the chat box. One question relating to this internal aid and external aid is bothering you people. Try to understand when we say internal aid or to the constitution, internal aid of construction, it basically means anything which is mentioned in the legislation which you utilize to interpret the provision is called internal aid. Anything which goes beyond the law, which you are referring to, is referred to as external aid. So if, say, for example, parliamentary debate, history of that legislation, or any Supreme Court decision on that particular thing, these are all external aids to constitution construction. If you are referring to legislation, then it is internal aid to construction, which includes definition clause, it includes preamble of that legislation, it includes any other provision under that legislation. This is referred to as internal aid. Okay. We will throw more light on this when we learn interpretation of statutes. That is another section which you have to study. There I will explain it in much detail. Yes. Okay. Presumption against retrospectivity, Tambeshwari, is basically that any law which is enacted, it is presumed that it will not be having an retrospective application. So say, for example, Parliament passed the law today, or this data protection law, I have given you the example, right? So the data protection law, if it comes into force on particular day, or it is passed in 2023, it is presumed that it is not applicable to the things which have been done in 2020. However, if the legislature wants a particular legislation to apply from a retrospective date or a back date, that has to be clearly mentioned in the legislation. If it is not mentioned, then there is a presumption that it is applicable in future date, or it is prospectively applicable. I hope this answers your query. Any other questions you have? You can type it in the chat box. Any one of you have any question? Okay. What is section 4? Section 4, you want an explanation? I'm coming to section 4 in a while. Yeah. What else? Any question? So now let me begin with this preliminary section. Now I will take all the questions towards the end. Okay, let me complete this part and then we will open the floor again for questions. You can ask the questions then. So preliminary, that is section 1 of the General Clauses Act. It says a short title and it says this act may be called the General Clauses Act 1897. So preliminary is basically the introductory part of the law. So whenever any legislation begins, it begins with a preliminary. There will be an introduction part of the law, and it will generally contain the short title, extent, commencement, application, etc. And if you will see, the title basically is part of the act. It is not an enacting provision. Every act is given a title to carve out its own identity, just to like people are given their names to identify them. So the General Clauses Act contains only one short title in the preliminary part of the act. As you can see here, this act may be called the General Clauses Act. I gave you a comparison also between data protection law and General Clauses Act. You saw in the data protection law, there are 3 clauses mentioned. Here, it is only 1 clause. So depends on the legislation that what kind of a clause it will be. Section 2 is not applicable because it is already repealed. So let us not go into the details of that. Now, coming to the general definitions. If you will see the General Clauses Act, section 3, 4 and 4A, these are the sections which have been mentioned in this act and in all central acts. So this is what section 3 says. It says, in this act and all And in all central acts, the regulations made after the commencement of this act, unless there is anything repugnant in the subject or context. So this term you will find many places. Unless there is anything repugnant in the subject or context. Again, I will reiterate, context is the king. This is what this definition says. Okay, so you have to read these definitions from the context part of it. So if there is a definition which is there in General Clauses Act and there is a definition which is there in IBC, in both these definitions, if you are interpreting IBC, the definition under IBC will prevail over the definition in General Clauses Act. I hope this clarifies your point, and this is an important point which you should keep in mind. Context is the king. Section 3, subclause 2 defines act in the General Clauses Act, and it says, is used with reference to an offense or a civil wrong, shall include a series of acts and words which refer to the acts done, extend also to illegal omissions. Now here it is important that act is small act, not capital ACT. When you use capital ACT in running, that is basically referring to the legislation. But when you are using small, it is the action wala act. So act includes illegal omissions. So if there is an illegal omission, that will be included in the act also. However, if there is an omission which is not legal, which is not illegal, then that may not be considered as a problematic situation. Let us talk about it. If there is generally what happens is omissions, casual omissions, wherein I don't owe a duty of doing something and I omit to do that, that will not be considered as illegal. That will not be considered as illegal omissions. Illegal omissions are omissions where I am duty bound to do something and I omit to do. Then in that situation, it will be an illegal omission. But if I just, don't do it when I don't have a legal duty to do, that will not be illegal omission. So this is what is the definition of act in simplified language. Now, there is a definition of affidavit also. And along with affidavit, there are two more terms. One is oath and then swear. So subclause 37 defines oath, 62 defines swear. All these terms have been, see, if you will see your syllabus, every term has not been included in your course material. So I presume that those terms which is not there in your course material will not come in your examination. But still, I would suggest you just have a look at the legislation once, and broadly you should go through it once so that you have a general idea in your mind. So when you talk about affidavit, affidavit is defined to include, shall include affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. So affidavit can be done by two ways. Either it can be done by swearing in, or it can be done by affirmation and declaration. Generally, it is affirmation and declaration. Whenever there is a swearing kind of a situation, that is basically included in the, religion is included there. So say, for example, somebody is said, Gita pe haath rakh ke kasam khai. What is that? That is basically swearing. Whereas in case of affirmation and declaration, it is basically the declaration of the person to the conscience, you can say. So let us see the definition of oath. Oath is said, shall include affirmation and declaration in the case of persons by law allowed to affirm or declare instead of swearing. This is what is the definition of oath also. Similar is the definition of affidavit if you see there, right? Let us see what is swear. Swear is with its grammatical variations and cognate expressions. When I say grammatical variations and cognate expressions, it means that swear, you can utilize synonyms of swear. Okay. So it can be sapat lena, or you can say promise. So these terms, whatever term you use in relation to this swear, that will be included here. Okay. Shall include affirming and declaring in case of persons by law allowed to affirm or declare instead of swearing. So basically, swear, when I say I swear to God, right? So here, if I am believer of God, I can swear to God. But if I'm not a believer of God, then I have to do for affirmation and declaration, right? So in the affidavit, generally you will find these terms. So this is what General Clauses Act defines. Then there are some other definitions which are given in the General Clauses Act, and month is defined, and it says month shall mean a month reckoned according to the British calendar. Now, so they are utilizing in our law, we are utilizing British calendar yet. Now, recently you would have seen that a lot of people are saying that why we are using British calendar, can we not use the our ancient calendar? What is that? That is called Samvat, right? So these things are under discussion, but this is, since this is a legislation which was there at the British time, and everywhere in the world we are following British calendar. So this is what we are following here, is the British calendar. That is, month shall mean a month reckoned according to the British calendar. Year shall mean a year reckoned according to the British calendar. And financial year is defined here, shall mean the year commencing on the first day of April. So this is a very important definition for you people, right? Month, year, and financial year, because a lot of your work happens around this, okay? Financial year, starting from 1st of April until 31st of March, it ends. I hope these are a pretty clarified definition. You don't have to, go into much details of this. So it is clear to you. Now let us see this particular provision. This is quite an interesting one. So it says central government shall, and I think it is this definition of central government. Yeah, and you can see it says central government shall, in relation to anything done before the commencement of the Constitution, mean the Governor General or Governor General in Council, as the case may be, and shall include these things. So before the Constitution, right? If there is a term used central government, it will refer to the Governor General or Governor General in Council. But when we are referring to provisions relating after Constitution, it will refer to the President and will include the following. Okay. So in relation to functions entrusted under subclause 1 of Article 258 of the Constitution to the government of a state, the state government acting within the scope of the authority given to it under that clause will include term president. In relation to administration of Part C of the state, before the commencement of the Constitution, 7th Amendment, so and so, Chief Commissioner and Lieutenant Governor of the government of neighboring state. So this is talking about the powers of the Lieutenant Governors, and this, they will be considered as president, and they will be considered as central government for that purpose. And in relation to the administration of Union Territory, the administrator thereof acting within the scope of so and so will be considered as president. This is what, if you see part A, B, C, and D states, this is how the situations are. So former British provinces are called part A states. There are 9 states in it: Assam, Bihar, Bombay, East Punjab, Madhya Pradesh, Madras. This is what is the structure. Part B states: Hyderabad, Jammu and Kashmir. This is the organization of the states at the time of the independence and when the constitution was being framed. Now we don't have these part A, B, C, D states. When this constitution was getting there, then at that point in time, we had this particular states. Government or the government shall include both central government and the state government. This is what is the definition of government. Let me see this. Do that. Give me a second. The law also defines, interestingly, the India. India is also defined in this General Clauses Act, which is not part of your syllabus, but read, it is quite an interesting definition. Yeah. So it is central government shall. Okay. Right. So this is what central government definition is. There is no difference between the term purposes of the central government and federal purposes. Okay. Now let us move further and talk about other definitions. Section 3, subclause 7 defines a central act, and it says the central act shall mean an act of parliament and shall include an act made before such commencement by the Governor General in Council and Governor General acting in legislative capacity, an act of the Dominion Legislature, or as I told you before, there are three periods which you should keep in mind. One is the period before independence. There is a period in between before we got our constitution and our independence, and post constitution. So these are the three periods which it is referring to. And for these, each relevant period, there are different terms which are used as central government. So you have to refer to Governor General. If you are looking at the older laws, you will find Governor General and all those things. But most of the laws are now coming after the constitution. They are referring to President of India. So there is no confusion there. This is all about the older laws. Now, section 29, subclause 29, sorry, of section 3 defines Indian law. And it says Indian law shall mean any act, ordinance, regulation, rule, order, bylaw, or any other instrument. When we say any other instrument, means anything, any other instrument. It can be by whatever name, okay? Which before the commencement of the constitution had the force of law in any province of India or part thereof, or thereafter has the force of law in any part A, B, A or part C state or part thereof, but does not include any act of Parliament of the United Kingdom or any order in council, rule or other instrument made under such act. So this is basically saying that whatever laws which were applicable to the Indian territory will continue. Basically, this is what is the purport of this. And it will not include any act of Parliament of the United Kingdom, under that particular act. So it is basically anything which has happened in the territory of India will be considered as Indian law, and not something which has been passed in Britain that will be considered as Indian law. Okay. Now, enactment is, and I remember one of the political debates which was happening on television, and there were some people were saying that India's independence is on lease or something like that. They were discussing. This was by a wrong interpretation in their mind that British Parliament passed a legislation which is applicable to us. Because of that particular idea, it was there. So no law which is passed by British Parliament there is applicable to us. You have to see that whether that particular law has been passed in India or not. That is an important element which has to be looked at in this definition of Indian law. Now coming to enactment. Enactment is defined, shall include a regulation as hereinafter defined. I would like to put this particular thing in your mind is here regulation is a broader term. Okay. I told you the difference between act, rules and regulation. This is not that regulation. Here this regulation is a broader term. Okay. If you will see, and any regulation of the Bengal, Madras or Bombay Code, and shall also include any provision contained in any act or such regulations as aforesaid. Section shall mean section of the act or regulation in which the word occurs. Subsection shall mean subsection of section in which order word occurs. Rule shall mean a rule made in exercise of power conferred by an enactment and shall include a regulation made as a rule under any enactment. And schedules shall mean a schedule to the act or regulation in which the word occurs. So this is a very general thing which you will find in legislation. I have already explained you what legislation is. Let us now talk about commencement. So as I told you that a law or an act or a regulation may commence immediately, or it may commence on a particular day when it has been notified to commence, right? So it will come in the official gazette, the notification will come and then it will commence. Otherwise it can commence on the date on which the president has given the assent to that legislation. Official gazette is defined and it says gazette shall mean Gazette of India or official gazette of the state. So there are gazetteers. Every state has a state gazette, and every central government has the central official gazette of India, as I have shown you in the beginning, the picture of that. So everything which is notified in the gazette, a lot of things are notified in the gazette. Okay, appointments, the roles and duties, the presidential ordinances, many things are notified in Gazette. And it is an official record basically. So anything which gets published in the Gazette is the official record. Okay. I was reading the gazettes of British period of the area in which I stay. I stay in Sonipat. I was trying to read the Gazette. They have recorded everything. They have recorded even the birds which are found in this area, animals which are found in this area, local customs, everything they have recorded in that particular gazette. It's quite an historical information. This is what is the role of a gazette. Document. Document has been defined and it says documents shall include any matter written, expressed, or described on any substance by means of letters, figures, or marks, or by more than one of those means which is intended to be used or which may be used for the purpose of recording the matter. So you can see the definition of document is quite broad. So anything can be document. Like say, for example, I have this specs cover and I write something in this can be also a document, right? If there is a pottery, on the pottery, there is something which is written that can be also a document. So there is a seal on which there is something inscribed, that is a document. A piece of paper on which some inscription is there, that is a document. Or you can say nowadays, I was in a UFM meeting in my university and there were students who brought some chits and bits of paper. That is also a document. So this is what is the definition of a document in broader sense. So wherever you find this word document, it is a broader interpretation under the General Clauses Act. Subclause 65 defines expression as to writing. So it says expression referring to writing, wherever you find the word writing, shall be construed as including references to printing, lithography, photography, and other modes of representing or reproducing words in a visible form. This is what is referred to as writing. So, but this I feel writing is not some typing on a computer. That cannot be considered as writing. It has to be some way in a printed format. This is what writing would be. Can it be? Now the question is that you don't have to go to this particular part. If you see the definition of document and writing in Information Technology Act, it includes even computers, right? So a document which is prepared in a computer is also a document, right? So if you read this definition, it is very, very restricted definition, right? So here you don't read the definition of document in the General Clauses Act. You will see under the Information Technology Act. But if there is a legislation where document has not been defined, then in that situation, you can refer back to the Evidence Act. Sorry, the General Clauses Act. Well, now there are other definitions like government securities. So it says government securities shall mean a securities of central government or of any state government, but in any act or regulation made before the commencement of the Constitution shall not include the securities of the government of any Part B states. So this is what is the definition. I don't think that this definition is very much important. Immovable property, yes, this is an important definition, and we saw the example of that fishery rights. So immovable property shall include land benefits. I have already given you the interpretation of this particular term. We have seen the example of fishing rights also. Then movable property. It says movable property shall mean property of every description except immovable property. This is quite an interesting definition. You know, in law, generally we have these kinds of different definitions. What is a private company? The company which is not a public company is a private company, right? So this is what is the definition which is there. So here it is interesting, you know. So there is a case, or there is something which relates to. I'll pose a question to you people. What do you think? Electricity is a movable property or a immovable property? Electricity. Yes. Electricity. I gave this explanation. Videos and photos can be documents under the Information Technology Act. Yes, it is a movable property. Pallavi, okay, fine. Movable, 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 movable. Everybody says movable. Yes. But whether actually it is a property, movable property. Okay, wonderful. Good. Right. Okay. Interesting. So, electricity is a movable property. It is considered as goods because it is traded, it can be sold, it can be bought. So, that is why it was considered as movable property in one of the cases, right? Now, registered. Registered used with reference to a document shall mean registered in India under the law for the time being in force for the registration of documents. There is a Registration Act of 1908. Under that, registration happens. Then person shall include any company or association or body of individuals, whether incorporated or not. So what is this definition saying? That person will include even artificial person. Okay. So company is a artificial person. It is talking about association also. However, if you will see the definition of person under the Companies Act, it is very elaborate definition which is given there. SEBI Act, it is defined. So these definitions are elaborate definitions. There you don't come back to General Clauses Act to see the definition of the persons. Then 22 talks about a thing shall be deemed to be done in good faith, where it is in fact done honestly, whether it is done negligently or not. So good faith is again a very important term, and many a times you will see that particularly government officials, they will be exonerated for a particular task because that is being done in good faith. Okay, so good faith means no ill intention. Nobody should have ill intention while doing that particular task will be considered as good faith. But if it is done negligently, that is not bad faith. Basically, that is what you can say. That is not bad faith. That is negligent, but not it will cannot be considered as bad faith. Offense shall mean any act or omission made punishable by any law for the time being in force. So this is quite interesting. In crimes we say what is a crime? Crime is something which is made punishable by law, like a crime. If it is not punishable in law, then it is not a crime. Okay. So offense is similarly, if it is not made punishable, then it is not a offense. Then imprisonment shall mean imprisonment of either description as defined in IPC. So it is referring back to IPC for this definition. Now we come to section 4. Section 4, someone asked the question about it. Okay. And it says basically that the definition of certain terms, okay, unless there is anything repugnant to the subject or context to all central acts made after the 3rd day of January so and so, regulations made on or after the 14th day of January so and so. So if you will see this definition, it is a bit of a confusing definition, but it is talking about two situations. And this will get much clearer if you see the preamble of the legislation. So this is your General Clauses Act. Okay. And as you are able to see here, it is saying, what is the preamble of the General Clauses Act? It says, whereas it is expedient to consolidate the extent and extend the General Clauses Act 1868 and 1877, it is hereby enacted as follows. So you can see here, there are two periods mentioned in section 4, 1868, January 1868 and January 1887, isn't it? So these two periods are mentioned. These definitions which appeared in these legislations will be applicable here in this particular case. This is what it says. Okay. So this is consolidating those definitions and bringing it back here. So those definitions were defined there. Now they are brought here in all these particular legislation also. I hope this makes clear to you people. Okay, this is what it's saying. Particular, it is referring to the older law. So what 18 what 1897 law has done, it has consolidated 1868 and 1887 law and brought them into together. This is what section 4 says, and this is what is the meaning that. Then application of certain definitions to Indian laws, and it talks about again similar kind of a situation, and it says basically the definition of Indian laws, like if you read here, it says the definition in section 3 of the expression British India, so and so, so and so, unless there is anything repugnant in the subject or context to all Indian laws. So this is what shall apply to all Indian laws. So these definitions will apply to all Indian laws. This is what it is mentioned. In any Indian law, reference by whatever form or words to revenue of the central government or state government. So if you see previously for revenue, there was a different term used in British India. But after the commencement of the Constitution of India, it will be referred to as Consolidated Fund of India or Consolidated Fund of the State. If you see Constitution, in Constitution, Article 266 defines Consolidated Fund of India and states. And it says, as you can see the definition. So it is saying basically that anything which relates to finances, which was there before 1950, first day April of 1950, will be construed as after 1950, 1st April 1950 will be construed at the Consolidated Fund of India or the Consolidated Fund of the State, as the case may be. So this is about definitions. I hope these definitions are clear to you people and there are no questions on definitions. Any questions on definitions? Yes. Any questions, any clarifications you have on definitions part? Section 3. Act. Okay. Act is basically talking about action. Okay. It includes even omissions. This is what the definition says. So it says basically that any act is basically a positive thing. No, you have to take an action. So that is what is called act. But it also include omissions. So even a passive thing, by ignoring something which you are duty bound to do, then that will be considered as an act, though it is an omission. And this is what the definition of the act says. What else? Any other questions? Yes, these two acts actually got consolidated in 1897. That is how General Clauses Act 1897 came into. So they have consolidated all the provisions of these two things and they have come up with the new. Whenever there is a consolidation of law, old laws get included into that, subsumed into it. Okay, now let me move further and talk about general rules of construction. Now, general rules of construction, as you are able to see in this slide, it has got these sections 5 to 13A. 13A anyway is repealed, 5A is repealed. So 5 to 13. Now it talks about many things. Now we will go one by one and try to read them and understand what they are saying. Okay. Effect of repeal. Section 6 talks about effect of repeal. And effect of repeal is a very important terminology. So there can be a repeal of the legislation, but everything does not end by that particular repeal, because any law which is there in force actually triggers many actions, many inactions, many omissions, many document filing, many rights accrue, many liabilities accrue because of that legislation. So just repealing the law doesn't solve the problem. And that is why in all legislations, you will find repeal and saving clause. Idea of this repeal and saving clause is that whenever a law you are repealing, the effect of that particular law should not hamper someone. Okay, you should have a continuity provision kind of a thing. So that continuity provision is being provided in these sections. So section 6 talks about that. And it says where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or thereafter, then unless a different intention appears, the repeal shall not affect the following. There are 5 things it should not affect. Okay. The first thing is revive anything not in force. So it should not bring into existence something which was not at all there before the repeal of the act took place. Okay. Revive anything not in force or existing at the time at which the repeal takes effect. This is one. Second, affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. Means if there is a penalty or a punishment which was there in the previous law, but now it has been removed, can you ask that, okay, fine, the punishment should not be given because so at that point in time the law was there and it was punishable. So now that will be punished. You cannot do anything in that because there is a suffering. You cannot plea that, okay, there is a suffering. So the General Clauses Act provides this. Unless the legislation specifically exempts that. Okay, so legislation has always a power. Okay, legislator can say, okay, fine, those are exempted. Then in that situation, it is okay. But if there is no specific exemption, then you have to go by section 6 of the General Clauses Act. Then affect any right, privilege, obligation, or liability acquired or under any enactment so repealed. Then affect any penalty, forfeiture, or punishment incurred in respect of any offense committed against any enactment so repealed. And lastly, affect any investigation, legal proceeding, or remedy in respect of any such right. So if there is a legislation under which a case has been filed, so that case will continue. So it cannot be said that no, now law is repealed, so case should go away. It will not happen like that. Okay? So this is the provision. Unless there is something which has been, as you can see, unless a different intention appears. So if the new legislation talks about a different mechanism to deal with it, then it will be dealt with accordingly. Like, for example, when this MRTP Commission was abolished and Competition Commission of India came up, there were matters before the MRTP Commission, 50 matters, which were given to CCI to look into it under investigation matters. And there were matters which were already concluded. Those were again given to the National Company Law Tribunal, sorry, Competition Appellate Tribunal. So like that, it has to be looked at. Just take this example of insolvency and bankruptcy code. So in IBC, section 243 talks about repeal of certain enactments and savings. As I told you the example, okay? Here it is clearly laid down. In detail, they have laid down what will happen to the existing law, what will happen to the old law, what will happen to the new law. So it will be working as per this provision and not General Clauses Act. I hope this is clear. If there is any confusion here in this, then people can go back to General Clauses Act to interpret. I hope this is clear to you. Any question till this point on repeal? I hope this is clear. Option 3. Okay, let me see. Option 3. What is that? Option 3. Option 3 is affect any right, privilege, obligation, or liability. Okay, so any person who is acquiring a right or is acquiring a privilege or is acquiring an obligation or liability. So wherever there will be right and privilege, opposite to that will be obligation and liability. One person will acquire the right, other person will have a obligation of honoring that right. If one person will acquire privilege, other person will be having a liability to honoring that particular privilege. Okay, so that if it is done under an old legislation which is repealed now, that things will continue. Nobody can say that, okay, fine, now law is not there, so we will not give you that particular right. This is what is the clause. I hope this is clear to you. Now let us move ahead. This I gave you the example. Now 6A. 6A talks about repeal of act making textual amendment in act or regulation. Okay. So it says where any central act or regulation made after the commencement of this act repeals any enactment by which the text of any central or regulation was amended, by the express omission, insertion, or substitution of any matter, then unless a different intention appears, the repeal shall not affect the continuation of any such amendment made by the enactment so repealed and in operation at the time of such repeal. Okay, let us look at the example of this 6A. Okay, what is saying? It is basically saying that wherever there is a act or a regulation is repealed, okay, by any new enactment, and there is a text of any central or regulation is amended by express omission. If there is a omission, insertion, or substitution, these are the three terms by which the law can be changed. Either a term is deleted, or a new term is inserted, or it is substituted by another term. Then in that situation, unless there is a different intention which appears, the repeal shall not affect the continuation of any such amendments made by the enactment so repealed and in operation at the time of such repeal. So if there is a change which is made, say many times it happens, you have to read this 6A with 8. Okay. And it says, where this act or any central act or regulation made after the commencement of it act repeals and reenacts with or without modification any provision of a former enactment, then reference to any other enactment or any instrument to which the provision so repealed shall, unless a different intention appears, be construed as a reference to the provision so enacted. It is a bit of a confusing. And many times I tell this General Clauses Act is not general, because general public cannot understand it. You need a lawyer to understand that. So basically, it is trying to tell that if there is a reference, say for example, in your course material, this example is referred to, and in an interesting example, it says in section 115 JB of the Income Tax Act, for calculation of book profits, the Companies Act 1956 is referred. Okay. Now, Companies Act got changed in 2013. You all know. So the corresponding change has not been made in 115 JB of the Income Tax Act 1961. Does it mean that the law will not refer to the 1956 Act or 2013 Act? Here, as per Section 8 of the General Clauses, applying Section 8 of the General Clauses Act, the book profits will be calculated as per the present Companies Act 2013 and not the old Companies Act 1956. So I hope this Section 8 is clear to you. Similar kind of a situation is Section 6. Then there is a term which is called revival of repealed enactments, that is Section 7. And it says, in any central act or regulation made after the commencement of this act, it shall be necessary for the purpose of reviving either wholly or partly any enactment wholly or partly repealed expressly to state that purpose. Okay, so one has to mention if there is a repealed enactment, and again it has to be brought back, there has to be expressly to state the purpose of that particular revival of that law. This section applies to all central act made after the 3rd January of so and so, and you know that 2 legislations which we have talked about. So these 2 provisions are not of that great much importance for you people. You can just refer to Section 8. That is very, very important, which talks about reference, because this comes many a times in Companies Act also. These provisions are there. Then there is a provision under Section 9 which talks about commencement and termination of time. So in any central act or regulation made after the commencement of this act, if it shall be sufficient. So I will not read the provision here, but try to understand what it is saying. It is saying basically that in the law, generally the periods are mentioned. Like for example, here the company declares dividend for its shareholders in an annual general meeting held on 30/9/2022. Under the provision of the Companies Act, the company is required to pay declared dividend within 30 days from the date of the declaration. Now here in this date of declaration is general meeting is held on 30/9/2022. Date of declaration, that is from 1st to 30th, will be taken into consideration. In this whole series, what you exclude is the first day, and include the last day. This is what this interpretation means. So you have to exclude the first day and include the last day. That is what interpretation is. Exactly, if you will read, for the purposes of excluding the first in a series of days or any other period of time, to use the word from, and for the purposes of including the last in a series of the day and other period of the time, to use the word to. Okay. Now, computation of time. So it says, whereby any central act or regulation made after the commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then if the court or the office is closed on that day or the last day of the prescribed period, this many a times happens. We will tell the students, okay, submit your assignment on Sunday, or maybe we will tell a date and that date falls on a Sunday. The students will ask, that is a Sunday, when do we do it? Okay, obviously apply section 10 of the General Clauses Act. That is the next working day. That is what it is. Okay. If it is done, we take the next day afterwards on which the court or office is open, provided that nothing in this section shall apply to any act or proceeding to which the Indian Limitation Act applies. Okay. So Indian Limitation Act has got similar kind of a provision, by the way. Okay. Where you exclude that particular period. Now, there are few more definitions, and these are very generic ones. First one, measurement of distances. So it says, in the measurement of any distance for the purposes of the central act or regulation made after the commencement of this act, that distance shall, unless a different intention appears, be measured in a straight line on a horizontal plane. You can see how specific sometimes the law becomes, right? So you cannot take a curved line. Like, say, for example, you have to measure a distance. So what you do is you take the tape and put it in a circular motion. So that will not be. So it is clearly saying, whenever you are measuring the distance, it has to be horizontal line. It cannot be the curved line. Then if you will see, it says duty to be take pro rata in enactments. So it's saying, whereby any enactment now in force or hereafter to be in force, any duty of customs or excise or in the nature thereof is leviable on any given quantity by weight, measure, or value of any goods or merchandise, then a like duty is leviable according to the same rate on any greater or lesser quantity. So it is saying basically that if, say, for example, 100 rupees is the custom duty on 1 kg of sugar, and if it is 650 grams of sugar, then pro rata basis, the duty shall be calculated. This is what it is trying to tell. Gender and number, it is interesting again, and it says, in all central acts and regulations, unless there is anything repugnant in the subject and context, this is very important, unless there is anything repugnant in subject or context, words importing the masculine gender shall be taken to include females. This is what it is saying. So wherever there is a term he used, you can read she. Now I feel this General Clauses Act should be amended, because in a number of new legislations, you are finding her as a term which is used rather than masculine. It is feminine which is used. So we are using she, her, and now after the recognition of the third gender as a gender, they are using neutral terms and they are including all these particular terms. So this is a very important amendment which it should do in General Clauses Act. And words in the singular shall be including the plural and vice versa. So this is about gender and number. So wherever you find he, you include she as well as the third gender. And wherever you are having plural, many a times that can be considered as singular as per the context. So you have to see this interpretation as per the context. So dear students, this is what was from my side today on General Clauses Act. We will talk about the remaining sections in our next class. And now I open the floor for any questions, any clarifications on any aspect whatsoever you feel like you can ask me a question, or any term which you feel is bothering you or you wanted to understand. No, it is not necessary, Hardik, to use the scale. You can use the tape also, but again, it has to be in a straight line. Repugnant. Okay, that's a nice question, Ritika. Repugnant. Repugnant means contrary, if I'm not wrong. Anything repugnant in the subject or other than this issue. Okay, this is called repugnant. Any further questions? Okay, how singular use plural? Okay. No, it is basically saying, Tambeshwari, that in a statute, if there is a word used single, if it is singular word used, and there are more people, like say, for example, it is using criminal, or it is using one criminal, or it is using, say, for example, murderer. Now there is only not only one murderer. It is referring to if there are four murderers, then it is you don't have to use the word murderers. Now you cannot make an argument before the court saying that no, law is saying only murderer. You cannot prosecute five people here, right? So that is what is the example. If that you are able to understand that. Okay. Yes. Any further questions or any clarifications you have? Please, you can ask the question. Any other question from any other syllabus you have? I will be happy to uh, take that question as well. Anything, any other topic or any question you have, any clarification generally you have other than accounts? No, come again. What was that question? Just a second. Yeah. Electricity is movable. See, electricity as such is not interpreted as a movable property, but it is considered as goods. So that is why it is called movable. And fish is called immovable because it is attached to a land. So fish cannot fishing. It is not fish. It is fishing rights, right? So fishing rights will be always attached to a land on which there is a water. That is why it is under the immovable part. Connoting. Okay. Connoting means basically meaning. So this connotes this. That means this means this. Construction of reference to repeal enactment. Okay. What is that? Which section you are referring to? Sabha. Section 5. Okay. Act comes 2nd January. So it is 3rd January on morning time. Not on morning time. It is 12 a.m. at the night. Give a second. Okay. Like meaning. No, see, it is not about government interpreting a particular thing. Okay. So generally, government's interpretation is not any aid to the construction, by the way. Right? You have to understand there are three wings: legislature, judiciary, and executive. So legislature, when enacts a law, it debates that particular law and it talks about the logic behind that law. So many a times when there is a confusion, when court is faced with a situation that it is not making sense, there are ambiguous terms, then it goes back to infer or get the intention of the legislature. That is what is an external aid to construction. Okay. Immovable property, dress until separated or immovable. Yes, you are right. You are right, Sai Kiran. Unless it is separated, it is immovable. After that, it becomes movable. Like say, for example, standing crops. Till the time it is attached to the earth, it is a immovable property. Once you cut that particular crop, it becomes a movable property, right? So if similarly in case of fish also. Yes, you are right, Ritika. Yes, British calendar is a calendar year, January to December. 6A. Okay. So it is basically saying that, see, any reference, I gave you one example in section 8, no? Similar kind of a thing it is saying. It is saying basically that if it gets repealed, then what is the effect? So say, for example, if we talked about Income Tax Act, right? So say Income Tax Act, if gets uses the Companies Act provision and Income Tax Act, Companies Act gets repealed, then what happens to those things? So those will continue. That is what it is trying to tell. Province of India. Province of India, where do you find this term, Province of India? This General Clauses Act uses the terms, pre-independence also. So when you are talking about Province of India, basically these were part A, B, C, D states, which I have discussed that. No, how can they be same? 6.8 is talking about change, repeal and substitution. And 6A is talking about repeal. Okay, that is the difference. Ambeshwari. 6A talks about repeal of the act, and 8 talks about references to the repealed enactments. Okay. Yes. Anything else which you would like to ask? Let me see whether I have missed any questions. Let me check the portal also once. Some people may have asked the question there. Okay. Yeah, some questions are generic, which I've already answered the questions there. Okay. What is affirmation? Okay. Affirmation is in affidavit. If you have a look at the affidavit, in there is a term affirmation which is used. Okay. In affidavit, we say, so give me a second, I'll show you oath affirmation and affidavit. Right. So you can see this particular document. This is Delhi High Court's practice directions. So you can see here, this is oath and affirmations. Okay. So this is appropriate form, oaths and affirmation. So you can see oath taken on Guru Granth Sahib, how it has to be done when oath and affirmation may be dispensed with. Then you can see these are the forms. Okay. So this is what is an affirmation. I solemnly affirm that the evidence which I shall give to the court, so and so, shall be truth, the whole truth, and nothing but the truth. Right? This is a simple affirmation. When there is a solemn affirmation, I solemnly affirm in the presence of the Almighty God that the evidence which I shall give to the court shall be the truth. Sach hoga, sach ke siwa kuch nahi hoga, right? You must have seen this particular dialogue many times, right? So this is what it is, affirmation. I hope this affirmation you got it. Okay. In the affidavit, this is what I think there will be a format also here. Yeah. So this is what is the form. This is oath and this is affirmation. Okay. I hope you got this. Yes. Any other question? Exhaustive definition. Exhaustive definition, basically, exhaustive definition. I told you basically that where means and include, these are the two terms which are there in a definition that becomes an exhaustive definition, which may include more examples. Okay, Hardik, that's a personal question. I think it was a wonderful experience, all obvious, okay, because that gives you a kick when you, it is just like practicing active like a CA, is similar kind of a feel you get as a practitioner. Yes. Okay, then I think your all questions are exhausted. So if there are no questions, wish you all happy Makar Sankranti, though belated. Looking forward to see you in the next session where we will talk about the remaining clauses. And if time permits, we will begin with statutory interpretation also. Interpretation is a big subject. We teach that in 60 hours. Now I have been told to teach it in 2 hours, to 4 hours almost. So I'll try my best to take you through the interpretation of the statutes. Okay, then all the best. Have a nice evening. Bye-bye.